In the spirit of all good clickbait YouTube videos, I'm here to promise you a simple solution to a very complicated situation. In this case, what is the secret to statutory interpretation? Now, it's obviously going to be trivializing the subject to think that in a short video I can reproduce everything that you've studied in an entire course on statutory interpretation. However, I do think that there is a simple idea that often gets lost in all the provisions and sections and precedents and legal foo-for-ah that tends to surround any topic that we study. And getting back to basics can help us understand what it's all about. So what is the secret of statutory interpretation? It hinges on the difference between the way in which words are written and what those words mean. That's what it's all about. The words on the page versus understanding what they actually mean. Now, obviously, that is the concern of a lot of other disciplines outside law as well, of literature, of poetry, of religion. A lot of what our cultural concerns are focused on is that ambiguity between the way we express something and what that actually means, because we know there are never the same things. We can write a word on the page, but in some ways that never really expresses what we actually feel about that word. So coming back to law, dragging the subject away from the poets and the philosophers, where it comes to law, we've got that difficult task of trying to regulate human behaviour, often including fairly abstract concepts such as harm and intention and good and evil and the whole shebang, in a set of simple, easy to follow instructions, relatively easy to follow instructions, or at least clear instructions where we use words. And in most cases, statutory interpretation is not an issue because those words are clear. When we say a dog, we mean a dog in most circumstances, unless it's one of those weird areas of law where we can probably prove that dog means cat. But those things don't happen very often. Where these tools become important is where there's ambiguity. And that ambiguity is generally something that is not foreseen by the person or people who drafted the legislation. It's because there's an unusual situation or because times have changed. And then we're called upon in the act of interpretation to actually look at the different meanings that can come out of those words and to decide between them. So, to be very, very clear, it's not the lawyer's job to take something that has a clear set of meanings and to say, let's obfuscate the issue, let's muddy the waters and let's make it unclear, although many lawyers do try to do that. It is simply the situation where we just don't know the way in which this term applies in the situation. It is not clear, and that's the role of lawyers then in proposing different meanings. And obviously, if it's in a context where you're representing a client or an organisation, you're going to be arguing for the interpretation which best suits their particular interests. Now, the rest of everything around statutory interpretation boils down to that core activity. Someone will say, I think it means this, someone says, I think it means that, and then you go back to your toolkit to try and understand how do we sort those things out. So we've got the Acts Interpretation Act that provide guidelines. We've got precedents that also suggest help with guidelines. And what these things often do is refer us to other sources to help us understand. Generally speaking, you're confined within the words of the Act. There are other words in the Act that might help you. So Acts have, say, a definition section that will help you understand what a word means. Or there's the presumption that Acts will use a term consistently throughout. So if it's used clearly in one section and you come back to the section you're looking at now, you might be able to say, well, it's in the parliamentary intent is that it would be used in the same way because it's used that way in this piece of legislation. But it does sometimes result in the situation where you have no clear help. Where do you go for additional argument or inspiration for helping to understand what these words mean, particularly if there's a large distance of time between yourself and the original creation of the Act? Where this comes up very often is in constitutional law, because apart from the difficulty of changing the Constitution and the requirement for referenda, there is a significant period of time and society has changed. So there are various approaches that we have used over time, and I'm not going to go through all of them here, but to suggest some of them to think about. One of the earliest versions was the historical original intention argument. This still has a big mythic resonance, particularly for Americans, for whom the founding fathers have a kind of a mythic sort of demigod resonance for them that we don't really have in Australia. We admire Samuel Griffith and folks like that, but we don't hold them quite in the same esteem that our American cousins do. And the idea is, under this form of analysis, is that you go back to what the founding fathers, the original drafters, intended, and as much as you can possibly do, say it should still apply that way now. There's problems with that. I mean, there are problems where meanings change over time and when society changes. So someone may refer to a weapon or arms in a old piece of legislation that perhaps is even before the age of firearms, where they're talking about swords and bows and arrows. Does that apply to firearms today? Do the conditions around, say, the US right to bear arms, which come out of the particular conditions of the Civil War, and do those still apply today in a society where guns are very, very different to the guns that were available then? Does it apply not just to the guns a person can own? Does it apply to your howitzers and your cannons and missiles and everything else you want to stock up in your armory if you want to be a true patriot and who is suspicious of all things in the government? So the historical approach is limited because of that, because it's an act of imagination where we don't really know what they thought, and you might be able to draw on some other documentary evidence, like a second reading speech before Parliament where someone says, "I think this means such and such," but it's usually the ambiguity is such that the elapsement of time makes that difficult. There is a further problem here, is that a lot of the interpretive work talks about the intention of Parliament, as though Parliament was one person who has an intention. Now, if you want to get into deep cognitive psychology, you probably would say that it's hard to really attribute one intention to an individual human being. We're actually a collection of very interesting and contradictory impulses. To try and say that there's one intention before an entire parliament of people becomes significantly more difficult. So again, it seems like a nice option to say, well, we'll just go back to what Parliament thought about the meaning of the word. But at the end of the day, that's something that's often impossible, because everyone in Parliament's going to have a different opinion. And yes, the minister might be the person who reads the speech and presents the act before Parliament, but that doesn't mean that person's interpretation is somehow elevated or better than anyone else who voted on it. The Prime Minister's intention is no better than any other backbencher or member of a minority party who also votes on an act. Parliament doesn't work like a monarchy. You don't get to be the king just because you're a prime minister or a president. You are all part of a representative body. So the idea of intention of Parliament is difficult. So there have been other approaches. I mean, there's been interesting attempts to use literary theory to help us understand, because these are something that literary theorists grapple with all the time. When Shakespeare said this, what does Shakespeare actually mean? And you actually see interesting situations where people can read a text against the grain of the text, or in a way that wasn't intended by the original author. So you have Freudian analyses of Hamlet that work rather nicely. They seem to work within the text, but certainly Shakespeare had never heard of Freud when he wrote Hamlet. So there have been some attempts to use literary theory. I'm not convinced that these are terribly useful all the time. One thing it does teach us, though, is that it is possible to have multiple readings. It is possible for someone to read Hamlet and to believe it's all about incest, for someone else to read it and believe it's all about existentialism, and for someone else to read it and think it's just about a prince in Denmark who's a bit sad a lot of the time. So I think that helps us ease our anxiety around the intention of Parliament, to say, well, a lot of words will often have multiple meanings, and the role of judges and to an extent the role of lawyers in presenting the different opinions on statutory interpretation is to negotiate those different meanings. And it doesn't mean that there's a problem that there's ambiguity there, because this is what we do. This is what judgment is about. It's about sifting through ambiguity and solving ambiguity. We don't need to feel anxiety about that. We don't need to feel there's something wrong with the legislation because it doesn't cover every situation. That's why we have a judiciary, and that's why we have lawyers to represent people's interests. And I think that's possibly a good outcome, and helps us realise that statutory interpretation is a creative process. It is something that is about an ongoing engagement with something that is live. It's not about summoning up the ghosts of the past and asking them what they think it's about and what they think it means. Final point I'd like to make around statutory interpretation is in the difference between technical and ordinary words. And this is something that's part of a much broader debate around plain English use in law. And I certainly appreciate the importance of access to justice and making law more transparent and avoiding some of that legal fidgy-widginess around terminology that stops people being able to understand what basic contracts and documents are. Don't have a problem with that. But I do have a concern that some of the more passionate extremists of the plain English movement don't like the use of technical words in law. And I think technical words have a particular place and a particular importance. And I think this also can help in a situation where a word isn't in common use and then doesn't have as many ambiguous and different meanings. Sometimes it is best to refer to something by a legal term, to refer to something as, say, as we do in criminal law, the mens rea for intent. Because intent is a word we have lots and lots of meanings for. Mens rea, yes, it's Latin, it seems elitist, it seems less transparent, but it's something that has very technical meaning, and there's a whole lot of precedence around it, and it's something that we can work with. So that's a little bit of a side point, but I think it's worth thinking when we think about this interpretive process, that it's not just about making a particular version of the law that's plain and therefore easy to understand. I think that can often make it more difficult to understand as you move away from the technical specificity to those more common words that then have all these constellations of meaning around them. Alright, so let's recap on the secret of statutory interpretation in 5 days, in 5 steps. Just send the money to my PayPal account. It's all about words and meanings, and about that interpretive process. We exist in a culture where the way we govern ourselves and govern others is through words, about written words on the page. Those words can never ever encapsulate the complexity of the things that we're trying to do in the governance process, but it's what we've got to do. And the role of us of ourselves as lawyers in the statutory interpretation process is a very valuable part of that. And it's providing that slippage, that ability to have these rules function in society. So you don't have a legalistic system, that sort of dystopian system where the law is applied strictly every single time, whether it's fair or not. We have a little bit of wiggle room in there, but we also provide the best quality professional advice and service to people who need help in representing their opinions and being able to argue in favour of the definitions that most benefit them.